Hello and welcome back to my channel. And today is a very strange situation where I have to deal with a particular judgment of Patna High Court. According to me, with all due respect to the court, according to me, it is an incorrect proposition on which this judgment is based. In fact, I would say the observations are disturbing observation. In my view, it is completely disturbing observation. So I dissent with this finding. Now, the basic premise of this judgment is calling wife bhoot, pishach is not cruelty. This is, and therefore, Patna High Court sets aside 498A, that is dowry proceedings against husband. And to my mind, this particular observation by the court itself, and that to the highest court of the state, that is Patna High Court, is very disturbing. We have often seen that demeaning or naming the females Kulachani, Kuntha, Dayan, kind of, and naming by other, or rather calling by other derogatory words, which is in my view is not done, and that's what precisely it has happened in this particular case. It seems that there were certain matrimonial discord in the husband and wife, and the husband, it seems that, would call his own wife as a bhoot, pisach. That is what that is the contention of the husband's side. That, I mean, even if I say so, even if I call my wife as a bhoot, pisach, dayan, whatever, it doesn't mean that it's a cruel, and so the concept of cruelty will not be applicable. So this, in my view, is been having accepted by the High Court, is not an appropriate finding. That's what the issue is, and this is decided by the Patna High Court Justice Vivek Chaudhary, who has come to the rescue of the petitioner, who in this case is husband, who was facing the 498A, that is the dowry harassment proceedings, and eventually it quashes those proceedings, and that's how this judgment is. So the brief fact of this case is the father of the wife, that is filed a complaint in 1994 before the Chief Judicial Magistrate Nawada. Nawada is a place in Ara district, or rather Ara is again a district, and against the husband and their family, inter alia stating that his daughter, that is the complainant's daughter, got married to the husband, and she was subjected to the physical and the mental torture on account of dowry demand. Then thereafter, the said complaint was referred to the police station under section 156(3) CRPC, and accordingly a case was registered under section 498A, which is dowry harassment, 323, 120B, 340, 386, all these penal offences concerning to the harassment of that lady who was a wife of this petitioner, who was the petitioner in the High Court. On the completion of the investigation, the police submitted the charge sheet against the petitioner, that is the husband, and 11 other named person in the FIR. And both the trial court as well as the court of appeal, that is session court, convicted and sentenced the petitioners of a rigorous imprisonment of 1 year for the offence under section 498A, that is dowry harassment, and a rigorous imprisonment of 6 months for an offence under section 4 of the Dowry Prohibition Act. In challenging this conviction by the court of appeal, that is sessions court, the husband, the convicted husband, moved to the High Court against the impugned judgment, where he argued that there was no specific averment in the complaint as to how and who demanded dowry, and when it was demanded, and how the wife was tortured. It was also contended that she was never medically treated for such any torture as alleged. On the other hand, the counsel for the wife's father argued that the petitioner's husband and their family members used to abuse her by calling bhoot pisaj, and that by saying so they inflicted immense cruelty on the wife. This is the basic premise, and then the High Court went on after having heard the arguments from the both the parties. High Court went on observing, and that observation is in quote unquote I am stating. The court rejected the argument that by calling wife bhoot and pisaj, the husband has inflicted cruelty on his wife. The court also observed that though the wife stated in her evidence that she informed the matter regarding the torture to her father by the series of letters, however, not a single letter was produced by the de facto complainant during the trial of the case. The court also noted that no document was produced to show that contesting petitioners personally demanded a Maruti car, and non-fulfillment of such demand, the wife, that is daughter of the de facto complainant, was subjected to the cruelty. The court also took into account the fact that no specific distinct allegations were made against the husband or his family, and that's how the court sets aside the conviction. That's okay if you set aside the conviction under 498A on the merit for the lack of evidence. That is one thing. I completely concede to the fact that if there is no evidence or material on record on the basis of which the conviction by the session court could be termed as a right conviction or a legally tenable conviction. So in absence of any such material which was not there, and yet the petitioner was convicted, that conviction could have been set aside in its wisdom of the Honorable High Court judge. But while doing so, specifically commenting upon the contention that the husband used to call wife as a bhoot and pisaj, and that is the one thing which has subjected the mental harassment or the cruelty on the wife, and that is been disregarded and discarded entirely in its entity, saying that it doesn't mean that by saying so it would amount to cruelty. So that is to that limited extent I dissent with this judgment. I don't think that it was an appropriate way of putting its own finding. Needless, some caution should have been observed, because it is certainly that when you call or you name your wife, or for that matter any woman, as a bhoot, pisaj, Diane, Kulachni, and XYZ, which is nothing less than demeaning word, it is an cruelty. Just imagine if the other way around, the women start using such a filthy words against the men, and they would run from pillar to post to prove that it is a cruelty. So in my view, to the extent of that particular observation, that name calling the wife by bhoot and pisach is not a cruelty, in my view is a disturbing observation, and it could have been avoided. That is whole bone of contention as far as this judgment is concerned. And the rest of the judgment of setting aside the conviction on the merit, I do not see any reason to make any comment upon. If there was a lack of evidence, certainly the conviction should have been set aside, and it is rightly been set aside. And this is what the whole context on which today's video is based. I hope you have liked these videos, and I will keep on uploading the different videos in coming days on the different legal aspect, and I hope you will keep blessing me with your support. And thank you very much. Have a nice Saturday, have a nice weekend, and thank you very much.